We were expecting an outcome, which I'm sure we've achieved, that national and subnational systems and institutions plan, fund, and deliver evidence-based programming that prevents and responds to violence against women and harmful practices in all sectors. And we have hoped, and which I'm sure we've achieved, the capacity building of law enforcement agencies and prosecutors in Abuja so that they will be in a better position to deliver justice for those who are survivors of violence against women and girls. And we took the objectives of the workshop from the supply side because the fundamental basis of government and governance is the security and welfare of the people. And there's no way you can talk about security and welfare if you don't have security. If the place is not secured, you cannot defend law and order or protect the rights of citizens and their properties. So it is against that background that we sought for a deep appreciation and understanding of how violence against women relates to law enforcement and what law enforcement agencies can best do to prevent and respond to it. First of all, the observations are as follows: that law enforcement agencies have a fundamental obligation and duty to protect and respect human rights and fundamental freedom. Of course, this includes the right to dignity of the human person and non-discrimination for women and girls and vulnerable groups. And the fulfillment of this obligation will definitely entail that women and girls are free from sexual and gender-based violence. Secondly, we observe that there are a lot of laws applicable in Nigeria with also extant policies that seek to respond to the challenge of VAWG. And this includes the Constitution of the Federal Republic of Nigeria 1999 as amended, the Revolutionary Violence Against Persons Prohibition Act, the Child Rights Act, the Police Act and its regulations, the Compulsory Free Universal Basic Education Act, and Trafficking in Persons Prohibition Act. These are all domestic laws which you can plead before our courts. Then there are international standards which include the Convention on the Elimination of All Forms of Discrimination Against Women, the Sustainable Development Goal 5, and Declaration on the Elimination of Violence Against Women, the Beijing Declaration and Platform for Action, Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, and the treaty components of the International Bill of Rights, which is the International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights. We welcome the establishment of the gender units in the Nigeria Police and in the NSCDC, as well as the establishment of the FCT Gender-Based Violence Response Team. But we noted that despite the establishment of these units and teams, they have not been adequately resourced. We also noted that there's no dedicated court for the prosecution of violators of SGBV and violence against women and girls. And this has led to the denial of justice because it slows down the process and sometimes complainants get tired and leave the case to God, as we used to say in Nigeria. We also noted that the awareness and sensitization of the processes of reporting, following up, facilitation, and getting justice on SGBV issues is very low. Hence, the need for increased public sensitization. In all the agencies that are tackling these great challenges, they have problems of logistics, inadequate training, unavailability of forensic tools and experts for the investigation of SGBV and VAWG. And this includes, of course, all the agencies here, the police, NSCDC, NAPTIP, and the SGBV response team. We also noted that contrary to legal provisions, that sexual and gender-based violence manifests in various dimensions in the home, in the community, public places and places of work. And this includes domestic violence, emotional violence, rape, sexual harassment in schools and workplaces, stalking, female genital mutilation, femicide, denial of education, disinheritance, widowhood practices, stigmatization, and shaming. We also noted that violations of the sexual and reproductive and health rights of women and girls manifests in forced marriages, child brides, teenage motherhood, forced pregnancies, denial of maternal care, including antenatal and safe delivery, VVF, unsafe abortion, and denial of use of contraceptives. Of course, we are living witnesses that our population is growing in geometric proportions, while it is outstripping economic growth. We are growing at about 3% a year in terms of the population, but as at today, economic growth has entered negative territory. We also noted that all these vices are obstacles to the achievement of equality, development, and peace, nullifies and impairs women's enjoyment of their human rights and fundamental freedoms, and they constitute global health challenges and causes physical, psychological, and economic harm and suffering to women and girls. We further noted the culture of stigmatization, silence, and shaming of women and girls who complain about sexual offenses, as this contributes to perpetrator impunity and the continuation of SGBV. Again, we noted that the Child Rights Act applicable in the FCT recognizes 18 years as the age of majority and informed consent. Therefore, anyone below the age of 18 is deemed to be a child by law, and sex with any such person is a criminal offense under the Child Rights Act. Finally, we noted the pivotal role of effective criminal investigation, because the way you investigate and compile the case file to a large extent will depend on whether you will have a successful prosecution in a court of law. Finally, we noted that the survivors of SGBV, VAWG, HP, they need rehabilitation and integration. Based on these foregoing observations, we now resolved as follows. 1, law enforcement agencies commit to redouble their efforts towards eradicating these vices. Interagency collaboration will be encouraged and strengthened, especially a platform for information sharing and exchange. 2, they commit to the development of a common law enforcement standard operating procedure on SGBV, as well as specific gender policies for different law enforcement agencies. 3, they commit to provide information for the publication of details of offenders in the Sexual Offenders Register, which is kept by NAPTIP. 4, that the gender unit should be adequately resourced with financial resources, capacity building for key personnel, logistics needed to support operations. And this does not apply to only the police and NSC's gender units. That NAPTIP and the FCT gender-based violence response team should also be adequately funded. The agencies here commit to establishment of a one-stop center responding to SGBV with multiple competencies, including the legal capacity, medical, investigation, psychosocial support, and shelter for abused women and girls. They commit to advocacy for the establishment of a special court to expeditiously try cases of SGBV and the denial of the sexual and reproductive health and rights of women and girls. G, they commit to engage other stakeholders in the struggle against SGBV, and these include the legal and medical professions, counselors, women's rights groups and associations, civil society organizations, religious and traditional institutions.